And we're live. Awesome. Okay. Thank you for getting us ready and rolling. Hey, everyone. We'll do just a little bit of housekeeping and then three guys with varying degrees of hair will share all we've learned about the update on the commission lawsuits settlement from today. So a couple housekeeping and disclaimer items out of the gate. Just quick reminder, look, none of us are your attorneys. Only one of us is an attorney. The other two guys just stayed at a Holiday Inn Express last night. So we don't, we're not representing you. We are not your broker of record. We are three people who spent months and months and months sort of spreading the good word or bad word as it may be on this specific topic, and know as much or anyone in the industry about it. We got the settlement this morning, just like everyone else, and we have been poring over it over the hours and on tons of phone calls, texts, emails, etc., trying to sort through it all. So we do not have all the answers. We don't know everything yet. We are going to share with you as much as we have been able to consume and share it with you in hopefully layman's terms and in a knowledgeable fashion to help you have some context. My guess is we could do a webinar a week on this topic for several weeks as more and more information comes out. So just quick reminder, we're not your broker, we are not your attorneys, but we are knowledgeable on this topic and excited about the conversation with you. Also, too, because of the setup for this and it being through Inman and streaming on their website, the questions will be turned off. So we will not have the ability to take questions, but we've done a pretty good job at trying to prep all these. So let's do some quick introductions. I'm Keith Robinson. James and myself have a podcast called The Real Estate Insiders Unfiltered. We also have day jobs running real estate companies in the industry. Excited to be here and spend a little time. James, why don't you say hi to everybody?
Same thing, CEO of Next Home, and then also help run the podcast with Keith. We do that in our part-time, which has been a lot of fun. And we've had Ed, who can introduce himself in a second here, on our podcast many times. And it's definitely one of the authorities in the industry on sort of what's happening with the cases and keeping everybody in the loop. Ed, we'll turn it over to you real fast.
Sure. I'm Ed Zorn. I'm the Vice President and General Counsel for the California Regional Multiple Listing Service. I've been a real estate attorney for about 30 years, including spending some time as a plaintiff's attorney in the courtroom. And I've also been a realtor for 20 years and still help people buy homes in my hometown.
He's one of us.
Yeah, perfect background, except for the plaintiff's attorney part. We're mad at you for that little slice of your life. Okay. First question, really important. This morning, when you checked your email, did you decide on whiskey or screwdriver? How did you, what was the first thing you did?
I'm a big beer guy, know, but a shot of whiskey probably would not have been bad when my phone started blowing up at like 7:30 this morning. So
it was early this morning for sure. So, all right, let's, Keith, we'll dive in. I'll take the first question. Lots changed this morning as we all found out about the settlement with NAR. So I wanted you to catch us up on where we are procedurally with everything with the proposed settlement. Is everything else on hold now? Like we were moving towards injunctive relief and all these other parts. So can you give us sort of where we are in context with this new settlement proposal this morning? What is the process now?
Sure. I think it's a really great place to start, right? And that is, where were these processes at? We all are fully aware of the significant judgment verdict from the jury that happened in the Sitzer case. We were at a period of time of post-trial motions, very normal in these kind of cases. The judge had a schedule for briefing. Some papers have been filed, some actually excellent papers from NAR and the corporate defendants on that, with probably a hearing sometime towards the end of April from the court. Now that probably process will be at least put on hold as it relates to NAR. There's still some corporate defendants left in that case, so that case will move on as to them. So the case doesn't end with this proposed settlement. And remember, it's a proposed settlement. Right. So there's still procedures of getting approved, people having an opportunity to be heard on it. these kind of things moving forward in the future. At the same time, James, there's all these copycats that we've been talking about. I think we're at 23 at the moment. There is a hearing that is going to be happening in the last week of March in front of a judicial panel from multiple districts that kind of look at litigation that happens across the country that's very similar. And for judicial economy, they try to consolidate those cases to a single court to handle a lot of the preliminary work, the discovery, the case management of it, usually in an effort to try to get it to settle. Right. That motion is still pending. That's still going to be moving forward as to how they handle those cases, although the relevance of most of those cases are going to be called into question because this particular settlement we're going to talk about today includes a class of all sellers across the entire country, which mirrors what a lot of the plaintiffs are in some of these copycat cases. So there's a mechanism in place that could help resolve some of those other cases, meaning those sellers would already get relief from these kinds of settlements.
And is that something they have to agree to? The other cases would have to agree to that? Or is if and when we'll get into this, we're going to open up another class in this. Does that mean that those go away? Like how do these 23 additional or 20 additional cases kind of go away with this proposed settlement?
Yeah, good question. It really functions very similar to the other settlements we had talked about, Anywhere, Remax, now Keller Williams more recently, right? All of those cases involve the making of a national class. Right. And so as opposed to thinking about James's individual cases, start thinking about individual sellers, right? So if I sold a property, 2.5 years ago, which I did actually, and I'm now a member of the settlement class that is part of these cases that are being resolved, right? And that's going to be the Burnett Sitzer, Morrell, the No Select case, right? So now I'm a member of that class. So what rights do I have to bring my own lawsuit? They can opt out of this national class as an individual seller and say, no, I want to go it alone. I want to go hire a lawyer and I want to go after this alleged damage I've got all by myself, right? Or I want to stay part of this other group or team and go ahead and spend all that money all with a small, tiny group, right? It's very, what you're going to find, James, is very unlikely that the sellers are going to do that or make those kinds of decisions.
Is that similar to like when you get the notice in the mail from Verizon saying that you can join the class and get $5.10, and if you didn't want to, then you can go file your own case against Verizon? Is that conceptually the same concept?
Correct. Yeah, you can spend $300,000 on a lawyer and enjoy your $5. Yeah, and that's kind of that concept. So it kind of, if you will, takes care of itself through the making of the class at the seller level. So think about it more as the sellers have those options as opposed to like individual cases.
This is an attempt to just sort of keep it simple. I know there's more technicalities to it, but in essence, to sort of roll everything up to get clarity so that both plaintiff and defendant can move forward, right? But specifically in this case, the plaintiff has the ability to sort of put a bow on this and move forward with their life, right?
Absolutely, right. If a seller thinks they've been damaged, they can make a claim under the terms of these settlements. There'll be some pot of money that gets divided based on how many people make a claim, and then they move on with life.
Yep.
And then parties are released. So this is a very normal process. They're very hard to put together. They're complicated. So I'd like to applaud NAR. And their legal team, Ethan Glass, Katie, they've done a good job. This is a very, very hard thing to do. And to pull it together is noteworthy. And I think at least a shout out to their efforts. And I do know that they really wanted to get as broad and as many people in the settlement as was absolutely possible. I think they did a pretty good job of that. But, they're limited by what plaintiffs will agree to.
Sure.
Right. And so they got to do what they got to do. So,
and we'll unpack that.
Them.
We'll unpack that a little more later. So for the folks who are transacting residential real estate, and again, just a reminder, this is a proposed settlement, not a settlement. So let's talk about this proposed settlement and the terms and the rules and the procedures around transactional real estate and how might my life be different in the future if this goes through as written.
Right. I guess hopefully your life really won't be that different. As an insurance broker, right? That's kind of the overall goal.
Say that again louder for people in the back.
Yeah. There doesn't have to be a massive shift in what you do. Hopefully, if you've been kind of listening to some people saying about what might be coming. And if you're a big believer in the code of ethics and the concept of buyer representation agreements, there may be not a big change, for you. So let's go over what some of the rule changes are that are going to impact the agent, the consumers. The first one is this settlement is going to require by MLS rule, before you get access to a home, you're going to have, as a buyer's agent, you're going to need to have a written contract with your buyer. That contract's going to have to deal with compensation. It's going to have to be straightforward, right? You can't put in words that say, well, whatever the seller's going to pay me is what I get, right? There's going to have to be some clarity in what the buyer and the buyer's agent are agreeing to with regard to the buyer's fee. Okay. In that agreement.
In the general parliamentary of transactional residential real estate, it could be called something different in the future. Of course, it won't. Even if it is called this, it wouldn't look probably exactly like is today in the various states. But would another phrase for that be a buyer broker agreement, or would you call it something else?
I would call it a buyer representation agreement, because I think our industry needs to maybe do a little bit of a better job of making these a little more friendly for the consumer. We all have our lawyers, we all brokers, we all understand our lingo. But in this world now where you're going to be communicating things to buyers and consumers, you may want to really think about, a buyer representation agreement, right? That deals with some broker fees and how you're getting paid, right? One of the other elements that's going to be required in that contract is a statement in the agreement that says if the buyer representative, the buyer's agent, and the buyer agree to a certain fee, then that's the fee the buyer's agent is going to get. And if somewhere in the transaction, some third party, that means seller, that means listing broker, is going to pay some portion of that buyer fee, it cannot be more than what the buyer and the buyer's agent agreed to. That really goes to the heart of what we've talked about before about the criticisms from the DOJ and the consumer advocates, right? That it should be the buyer and the buyer's agent that negotiate the fee that the buyer's agent gets paid. And that's the fee that should get paid. And
in advance of any
shouldn't get to
property.
manipulate that.
In advance of any property that they're looking at, to be clear, it's before they show a property now, correct? That's how I
absolutely understand. Yeah. That is the other aspect of the rule, is it needs to be done. And so it goes for, as an MLS, how we're going to incorporate this is really as part of the access rules, right? To be given permission to get into a property, you need to have this agreement done.
You've said this before. I want to reiterate this. There are actually a lot of positives to this, not only just for the buyer, and everyone's thinking the agent, but there is positives for the buyer because we're establishing fiduciary upfront, correct? Yep. Right. Yep. We're actually saying what we do and how we get compensated and what I'm going to do for you. But there's also benefits to the seller. Can you go a little bit into that as well?
Yeah, I think from the seller's perspective, it makes it easier to understand his side of the transaction. Right. So right now, almost every listing agreement's got an entire page about sharing of commissions and how it goes back and forth. And the seller has to kind of wrestle with how much is my agent getting paid and how much are we paying this other agent who may be fantastic, who may know nothing. Right. And so not getting kind of confused or bogged down with that, I think it'll make a lot of clarity for the seller going, hey, my listing agent, I'm going to pay them this amount for them to market my property. Now, nuanced inside of some of these rules, are still some opportunities for the communication from the listing broker to the seller on how buyer agents get paid and the importance and some benefits of participating in that process.
So maybe just to put the bow on one of the other big ones, because I don't think we've spoken about this specifically. Historically, the comp has been determined by compensation in the MLS, right? They're cooperative in the MLS. That is going away, gonzo. Again, if this proposed settlement goes through, that will no longer be the case, which is why we'll have to have these discussions about compensation in a different way. Is that accurate?
Exactly, Keith, right? So one of the other big aspects of the settlement as an MLS now, we're going to be forbidden from having a field that is a blanket unilateral offer of compensation, right? Which is how it works now. So right now what happens is we have this field, you put usually a percentage in that field, and then all I have to do as a buyer's agent to get that amount of money is bring you a buyer that closes, and then I get that money.
Mhm.
And so that field will now be eliminated from the MLS by this settlement. But again, like everything else on the settlement, there's some layers of nuances around that.
Right. Yeah. Yeah. So does this mean now that a lot of this discussion around compensation, who gets paid how and what, is going to end up in the offer writing process as opposed to in this de facto MLS clear cooperation process? So it'll be now more at the offer level instead of at the macro level?
I think it'll be a little bit of a blending, right? So one
Yeah.
of the nuances that's going to be permitted under this settlement, while we're not going to have a contractual blanket offer of compensation from the listing broker going to the buyer's broker. And by the way, the rule says you can't substitute the word seller for listing broker in an MLS rules, which was what we just went through with the DOJ comments on the no select case. So
Yeah.
that's not going to fly either. But they've been very clear, and I think the DOJ had indicated this as well, that the seller can still absolutely pay for the buyer's agent, just like they do today.
They clearly laid that out in their statement of interest.
Absolutely. Right.
Yep.
So now the question for us as an industry, and as we start to take these ideas here and implement them into your daily life through MLS rules and the process, is how do we do that? Right.
Yeah.
One way I think to do that is through a seller's concession, right? Concessions in list price is a field that CRMLS is actually going to be rolling out. We decided this months ago, back in November, and we found in 2023, 50% of the closed listings had some level of seller concession on it.
Did you say 50 or 50?
50%, 50%. Now remember, 2023, remember that little interest rate issue? And I went in and actually took one city in 1 month, and I looked at every single closing with a concession. There were 77 concessions on 150 closings. And a big chunk of them were loan buy down points, lots of sellers paying for title and escrow fees, right? Paying all the closing costs on that side. A lot of repairs, right?
Yeah,
so concessions is something we deal with, all the time.
Right.
So now the concept is, will the opportunity for a seller to say, I'm willing to pay some component of the buyer's representative fee as part of my list price. I'm willing to do that. Right. Here's a field that they can communicate that in, which is super important for consumers to know that this is still an opportunity. So while we can't have a blanket unilateral automatic contract being created with a field, we can have a field that communicates a willingness of the seller to do it. But just like a transaction where a seller says, hey, here's a $5,000 offer for a flooring credit, right? You don't get that automatically by putting an offer in, right? We all know as buyer agents, we have to actually write that into the offer. Right. So James, going to your point, right, that this now also has to be part of the written offer of compensation going to the buyer's agent. It's going to need to be written in. So no matter what concession is in that field, it's incumbent upon the buyer themselves to include that in the offer being made. And that makes it subject to negotiation from the seller, responding back, adjusting sales price, that type of thing. Again, exactly what the Department of Justice had requested in their filing the no select case is kind of delivered here, in this agreement.
You don't think they're going to have any issue with any of those two things? I know the DOJ's big thing has been steering, and candidly, I don't think they understand the definition of it, but that's my opinion. Do you think that they are going to have an issue with that seller concession field? I mean, let me back that up. Concessions are done in every single aspect of the American economy on a daily basis. I can't think of one thing I see online or anywhere that's not a concession to attract somebody to buy something. So are you worried at all that they might intervene? No? Okay.
Nope. I think this very kind of directly and cleanly takes care of the criticisms that the DOJ had of what we had. And the keep in mind what their criticism was, right? It was sellers and listing agents deciding what a buyer agent was going to get paid.
Yeah.
Right. Yeah. This is eliminated now by that.
Yeah.
And they want the parties through transparency to have an opportunity to negotiate things. This also delivers that. right? So
Yeah.
I feel like this exact rule, this settlement agreement of these rule tweaks and changes deliver exactly the things the DOJ says. So I would not anticipate there to be any
I have
problem.
a follow-up on that. So obviously in the no select case with MLS PIN not being an NAR governed MLS, this doesn't apply to them. Am I correct with that statement?
So the scope or the reach of the settlement agreement is only for NAR MLSs, and we kind of define that as wholly and MLSs, multiple listing service, that are wholly owned by a realtor association or
Got
a
it.
group of realtor associations, such as CRMLS, right? We have, I think, 42 realtor associations that are ownership. So that's kind of the element. But James, I think NAR did an excellent job of recognizing that while not everyone can be covered by this exact settlement agreement because of the challenges with plaintiffs not agreeing to that kind of ask, they did build in a mechanism so that a non-realtor, or we sometimes call them broker-owned MLS, can avail themselves to some aspects of the settlement, in that there's mediation opportunities and also a kind of buyout clause, right? That if you pay $100 per member based on how many members you had, I think I can't remember, it was 2023, or then you can buy your way out of the lawsuit and be covered by this. So while NAR wasn't able, because the plaintiffs wouldn't agree to it, even though NAR kept asking to make it as broad and be everybody, NAR at least was able to negotiate a kind of a quickie out, right?
Mhm.
And I think something that is some smaller MLSs that might be broker on may want to avail themselves to.
I've got a comment and then one follow-up question. The comment is based off of this conversation, like negotiation has always been an important skill in residential real estate, but it is about to become like very important. And so if you're listening and you're an agent or a broker owner, leading agents, it is time to find out about the real estate negotiation expert designation with NAR, or go read your favorite book on negotiation, because there's a whole new level of negotiation that could be coming soon that you are going to have to get good at. Now the follow-up question.
Wait, can I make one comment? I would call
please.
That's a money-making skill.
Yeah.
You need to have money-making negotiation, guys, because guess what? As a buyer's agent, which is kind of all I do, I get to negotiate my own fee.
Right. Yeah, there's no one who
Right?
said it. Yeah, exactly.
Yeah,
Exactly.
Keith, a lot of people are freaking out. And the way that I look at this is what Ed just said. I don't want the seller's agent dictating my comp.
Yeah.
And I'm like, I'm not afraid of this, but I do think that agents need to get really good at articulating their value, really good at explaining what they do. And the ones that aren't, bye. Like, not to be rude about it, but then like, you're not going to make it in this business. And this, ironically, in my opinion, is how we start to get the level of professionalism that everyone's been complaining about for a long time, is that we're going to force people to get better at their job. And in a kind of in a long-term vision way, I think this industry is going to I'm going to make this statement because it's going to irritate somebody, but I think that
You're good at that.
the goal
Here come
of
the emails.
it's fine. I think the goal of the plaintiffs and what you see in the New York Times and their biased reporting is going to be the opposite effect. I promise you, this industry is going to excel even more than what we did. And there's going to be a day where realtors actually charge more, because we're going to get better at what we do and articulate that value. And you're going to hear me talk a lot about that over the next 2 years. But I just wanted to state the fact that having that conversation up front with a buyer presentation and sitting down with the representation agreement and articulating your value and explaining all of that. I mean, tell me if I'm off, Ed, but that's going to make people in a more professional.
It will make them more professional, and it's okay to learn. It's okay to make a little less money than other people because you don't know as much. That's, guys, how the real world works.
Yeah.
Right? When I was a first-year attorney, trust me, I didn't make as much as I did when I was in year 15 of litigation, and nor should I. I didn't bring that kind of value to my firm, right? So yes, this will be a transition. People have to get used to it. there will be great money-making opportunities for great buyer agents who can sell their value proposition, who are good at negotiating, who can get first offers accepted in hot seller markets, right? I had to run a 14 out of 15 first offers accepted in 2021, right? So should I get a premium because I have that skill? Probably. But that doesn't mean someone who's just in their first year can't still go out, do deals. Maybe someone who has bought 4 houses and doesn't need that depth of skill can use a newer agent because they need doors opened and some basic information of a lot of. So there's going to be opportunity for all layers of experience and skill. What you're going to see, though, is those different layers will get different prices. And that's probably not a bad thing.
Well, and I think these are, look, the skills we're talking about have always been important. They now are becoming urgent because of an exterior force being pressed into the marketplace, right? So there's an urgency here that we want you all to hear. Hopefully you hear it in our voices. This is the time to level up your skills and get better at the craft of residential real estate, because it's going to be demanded in the future. All right, I've got a follow-up question before we move on, because you mentioned specifically that the offer for compensation couldn't be in the MLS, but what about like if I operated a portal, for example? Could I just stuff it there as a way to like not have it in an MLS?
Right, kind of like a ha ha ha. The MLS is going to get it.
Don't look over here.
Hey, I'll just put all the listings on my internet site and have a little section where everyone just drops in their offers.
Yeah.
No. There's a specific section of the agreement that says we as an MLS are required to kind of monitor this, right? And what it says is you as an individualized broker can get an IDX data feed from the multiple listing service, put all the listings from all of your cooperating agents on, just like you do today, and you, on your own listings, could put in some kind of offer of compensation or something, but only for the listings that are yours with your firm. You cannot put an offer of compensation from some other agent on your website. And there's a specific reference like internet data aggregators, right? Can't co-opt the system with this, or we as an MLS are required to cut their feet off according to this, settlement agreement, that we're supposed to kind of police that and make sure someone is not doing an end run around these rules and creating basically a separate system where there's offers of compensation and unilateral acceptance and these kind of elements on some site using our data, right?
Would that apply
to terminate your feed if you do that?
Would that apply both publicly on IDX as well as internally on VOWs? Do you know?
I would say yes. I would say the way it's phrased in the settlement agreements, I understand it, and I'm going to say this a lot as I understand it, having looked at it very briefly.
Remember, everyone, we got this hours ago.
That it's based on the data feed, right? So if you get a data feed from the multiple listing service of data, and you're publicly displaying everybody else's listings with offers of compensation on listings that are not your own, then you're going to have an issue with my licensing department.
Got it. Okay. I think we covered all of that on the settlement terms. Did we miss anything on that, Ed? Or we got that there? Before we move forward,
covered the fact that the buyer's agent's not going to get to keep extra money.
Yeah, we covered that.
Okay.
We did.
Yeah, we did. We covered all the terms.
Okay. Then let's go to this. So what cases are settled in this proposal? And then what is still outstanding? Like I read it as the buy side cases are not part of the settlement, as an example.
Correct. This doesn't deal with the buy side cases, which are having a big challenge getting through the systems, right? Lots of the buy side claims have already been kicked out just because they don't have the proper standing, because buyers weren't entering into contracts. So that's a big limitation at the federal level. So those cases are not resolved with this, but those are very weak cases compared to, what has been happening on the seller side. So that is still to be determined, though, that those are not resolved here. It's basically this settlement very closely matches at least the procedural framework of the earlier settlements that we saw with Anywhere, Remax, and more recently Keller Williams. And that was, we're settling these 3 cases, right? Sitzer Burnett, Morel, No Select, and then we're creating this giant class of all sellers across the entire country. And that is the class then that will really kind of knock out these copycat cases, because the plaintiffs in the copycat cases are also would be covered by the settlement in this class. So those people have to make a choice, right? Do I take the sure money in the settlement, or do I proceed with my own litigation? So
and so we're going to cover this in just a second with the terms, but just for clarity, the fourth class, with, just to recap, Keller, Remax, and Anywhere, total settlement amount of 208.5, I believe, 208.5 million for that. That fourth class gets open, so essentially all sellers in the US would be able to join over that. Is it a 4-year statute of time on that? That's 4-year.
yeah, I believe it goes backwards 4 years.
4 years.
And by the way, this resolution very much helps those settlements, right? One of the challenges, if you're a member of one of those organizations, was, like you just said, James, it goes back 4 years, I believe, when the settlement gets implemented, which will probably be sometime in May, right? But the day after the settlement gets implemented, you have no coverage or release.
Right.
Well, now that the rules are changing, right? The concept was the rationale and the arguments about the conspiracy and all of that will now be eliminated, right? And so even those people who settled earlier are going to get some quality benefit out of the fact that NAR is stepping up and the MLSs are going to be changing these rules so as to eliminate the risks of there being future problems.
Just to put a bow on that, what you're saying is, if we didn't change the rules, which is one of the things everybody's been like up in arms about, if we didn't change the rules, you'd have an entirely new class of plaintiffs potentially down the line, because all the same stuff was in place that's been in place before. Is that?
That's kind of how the argument would have potentially gone from a future
been
plaintiff lawyer who had a lot of time on their hands. Yeah.
Right.
This is an attempt to create clarity.
Right.
It's a lawsuit, so there's never clarity. But this is an attempt to create clarity, sort of closing the book to move forward. Since we are now to the point where we're talking a little bit about terms, what are the settlement terms? How is that going to unpack?
Right. So one is the rules that we talked about, right? And the rules being modified.
Yeah, I meant
that's one term. Then we talk about money.
Yeah, that's what I meant.
And so NAR is going to be coughing up $418 million.
Ouch.
The good news is that's spread out over 4 years.
Mm-hmm.
So it's not like they got to just, tomorrow someone's going to run in and cut a check, or, run to the bank and grab all the money. So that certainly that's going to be structured. And I think one of the things that NAR has already communicated out there is the fact that, NAR had other options in front of them. Just so you guys are aware, my best understanding is NAR probably had lots of opportunity to settle this case bunches of times for NAR. Right? And maybe for their local AORs, or maybe even for us MLSs, and leave all the brokers out there hanging. I think they absolutely had that chance, and they didn't take it. They went to the bat, they fought, and tried to get as broad of a stroke as possible to cover as many brokerage firms and agents as possible with this, and also implementing a rule that still preserves some quality aspects of transparency, communication, but that can still be very good for us as an MLS. We can lose compensation in an MLS as long as we keep cooperation. And I think this rule really does that. So I think the money kind of reflects the fact that this money is covering a lot of agents. I think they said in their writings about 1 million agents will be kind of covered, by this $418 million.
We're going to cover who's in it and who's not in just a second as well.
But Ed, you don't have to comment on this if you don't want to or aren't sure, but to my knowledge, you taught me that, there's not a dues assessment in 2024 for this, or that's not part of the announcement, that they're just taking this on the chin.
I have not seen anything that would indicate any pending assessment or something, but I'm assuming that's to be determined. That's an NAR question, and maybe someone could ask.
There is, Keith, there's nothing in 2024 that I've read, and I've talked to some people, and the to be determined is down the line. But to be clear, there has been no indication one way or the other from NAR on that, other than there's nothing in 2024 thus far with it. So
that's something.
So 418 million, that's a great lead into, you said 1 million people are covered approximately. That's what they had in their settlement terms, roughly 1 million people, which we all know there's roughly 1.5 million. So who is covered and who's not covered? Let's go
Right.
down that line. Yeah.
So remember at the beginning, you asked me where we were procedurally, right? So there are still some defendants in other cases, right, that have been filed that didn't participate in this resolution. And so those are not covered, right? Home Service America is the kind of the biggest one that kind of falls into that category. Then there's as these copycat cases have been occurring, what is normal is your giant companies, right? Companies that have lots of agents do, 4,000 or 5,000 transactions a year at the broker level, right? A brokerage firm that is that size. Some of them have been going directly to plaintiffs themselves, saying, "Hey, what's going on? How can I get out of these cases?" And so I think what kind of happened, or what my experience has been with these kinds of elements, would be the plaintiffs saying, look, those giant brokers who made really huge money off of this process should have to pay something different or a little bit more than, some firm where it had 6 agents and they did, a couple hundred deals in a particular year. So there's a carve out for any brokerage firm that did more than $2 billion in volume in 2022. So that's kind of the benchmark of who's in and who's out.
And
Just
they've
to be
specifically
clear,
referenced T360's list in the document as their evidence piece on that. So that list, which I believe is 94 brokerages, fit into that. What we don't know, Ed, is how many of those are part of Remax or Anywhere or Keller Williams, but there's 94 brokerages that are at or above $2 billion that are not included in the settlement today.
And just to be, let me just, because I want to make sure people understand this. This is at the local broker level, not at a brand level. So you mean
Correct.
a specific company that's owned at the local level doing more than 2 billion in transaction volume,
EXP, Compass,
or owned at the national
yeah.
level would be another
the
way to
big
say
the big
Correct.
guys.
a single brokerage company.
Yes, correct.
Right.
Okay.
And so, and you're right, James. You're talking a very tiny piece. Well, they may have a lot of agents, but out of that 94 or that group, you do have to remove, your Anywhere brands, your Keller Williams brands, your Remax offices that may have be at a size and doing that volume, because they're covered by their own.
Right, which is going to shrink that number down even further.
That should shrink that number down. Correct.
Yeah. So there's and the number that we read was 25 basis points, or 0.25% for everybody to follow that, of the total. We just looked at this. So it was the total volume.
Average.
So it's the average. So it's the average of the last 4 years. So you go through and do your volume for the last 4 years.
Yeah.
Average that, right? Take that total, divide it by 4. And then it's your 25 basis points to that number.
And that's the settlement if you want it, unless you're going to go.
If that number is $2 billion, it's $5 million.
Yeah.
Yeah.
It's $5 million per 2 billion in volume.
Well, I hope they have happy hour, those folks. Very simple.
So you can do some math on that, by the way. Sorry, I have to do my James things for a second. What's really fascinating about this to me is, well, don't laugh, Keith, because I'm right on this.
I know you are.
I'm saying this respectfully because I know, Ed, you're a lawyer, but you're talking about 418 million from NAR to cover, all the mid-sized and small companies, 208 million from Remax, Anywhere, and Keller. So let's just call it 600 roughly. And they're going to get maybe another couple 100 million, 300 million out of the rest of them. We never even got to $1 billion. And then if they took, in the latest proposal I saw the lawyers take, they wanted 82.5 million out of the 208 to pay for 96,000 hours of stuff that they did. But I'm just reading
for a 2-week trial.
I'm reading their comments. I'm reiterating back the stuff that I read that they wrote for their reasoning for $82.5 million. What's ironic is, what is it? They're going to take what, another 10, 20% out of all that other settlement, maybe something like that. The plaintiffs are going to get nothing.
Yeah. Cliff's notes is this is going to be one of those checks.
This is the largest money grab by the Lawyers Association I've ever seen in my life, because there's no way they're going to get the kind of money that they've been talking about. And if they're going to take 10 to 20%, and you bring in every single seller that sold a house in those 4 years, they're going to get like 10, 15 bucks when it's all said and done, depending on how many people obviously agree to get part of the money. But like, there's never been a scenario where they were going to walk away with thousands of dollars.
Well, even if you're by a factor of 10, which I don't think you are, so it's going to go from 15 to 150. Like this, it is frustrating. All this noise, all of this for an industry. I guess it's my turn to get on my soapbox. You can laugh at me now, James, but for an industry that in general is an incredibly wise steward of its clients, and a vast majority of the people show up every day and respect the fiduciary duty that they have, for all of this noise and pain and drama to be associated with it, it just is a very technical term that I learned in business school. It sucks. It just sucks.
All right. Well, look, I have another question. Because we only have another 20 minutes here. So, yep. Ed, they said that when the class notice goes out, you can be part of, if you're a member of NAR, when the class notice goes out, which I believe is July, then you could be part of the settlement. And this is me talking with NAR, and I might get this wrong, but does that, your understanding would be, if that's the case in July, if you're a member of NAR, and then you would be included in this settlement as long as you're a member by July, if that's when the class notice goes out?
That's my understanding. Again, I did not
I
have
understand we're speculating slightly,
pages, but that's my best understanding, is based on the NAR membership at the time of class notice at the, basically at the broker level, right? The broker principal has to be a realtor.
And then they would
just to go one step higher, right? Before that. So what is the timing for all of this in as far as the document and the process? Like if I'm an agent, I don't need to figure out how to talk about buyer broker agreement tonight, right? If I'm meeting with a buyer tomorrow. So what is the timing of this for transactional?
Right. That's a great point. It's really like mid-July, right? The goal that NAR is kind of put in here is mid-July, but realize all the work that has to happen at the organized real estate level. You're talking changing every listing agreement. You're talking about changing every buyer representation form. You're talking about changing every residential purchase agreement so that there's some kind of language that can incorporate the capturing of a concession and things inside of that, right? So whoever's doing forms work, hope you've already gotten your sleep, because you're not getting any in the next couple months.
Is that a realistic time frame?
I don't know. It depends on, again, hopefully people already knew this was all coming. And I can tell you from CRMLS, we've been working on this, concession list price field and talking about what the field should look like and the parameters for it for a couple months, right? So we're ready to implement probably sooner than maybe some others. I think, though, remember how we keep using this phrase, it's a preliminary settlement, right? It's a document, which is great, but there'll be some hearings on it. And so once we get our hands on some of the technology providers, right, the people who do the software for forms, can they accommodate that change by July or not? And if not, can there be a tweak at one of the court hearings to extend it a month or two, something like that, to make that accommodation? Yeah, I think these are not deal killing points, but there are things that the industry has to weigh in on as to what's possible, what are the best practices in organizing fields. Now, the good thing is, if everybody's got to do this at the same time, you don't need 500 different design techniques on how to do this. Right. You do this 2 or 3 different ways and roll it out.
Does this help in that there's, I think, roughly 14 or 16 states that currently have mandatory buyer rep agreements in some shape or form? The ones that have been dragging their feet for whatever political reason they didn't want to, does this help push it now for them to do it at the state level? Or is this every broker for himself now creates it in states where it's not mandated?
So you're talking the form itself. I think you're going to see, I think realtor associations are going to step up and make forms. Honestly, James, I think you're going to see individual brokerage firms step up and make forms.
Yeah, well, this seems
Guys,
like
this is a marketing opportunity, right? The ease of my form, how clear I am, how I articulate my duties, how easy and consumer friendly it is.
But isn't there like no guidelines on it? So you could put sort of whatever you want in those forms at this point? Is that going to be the next?
So when you
couple
say no
guidelines
guidelines and you can put
Yeah.
anything in, are you talking about things that are very broker favorable?
Yeah, sure.
Sure,
Yeah.
absolutely. And you're going to be met with a guy like me who's going to do a very nice consumer friendly form and make it super easy for the buyer to sign my form because I'm going to highlight my duties, my skill, my experience. I'm not going to have any gotchas or super broker heavy things in it. And so what you're going to see is some competition
Do
in
you
that
think that's
form
good?
space.
I was leading you, counselor, intentionally. Do you think it's smarter for the states to do it, to meaning that we get it mandated at the state level, or leave it up to free for all at the brokerage level? Like, what's your take on that?
And
Free
you're talking the
market versus
forms again
control.
too, right? Not like
Yeah.
legislation mandating.
Yeah.
I would say that's going to be dependent on the state. I think there are states that are very comfortable and the realtor community is very comfortable in making some of their own forms. I think there are other states where a realtor hasn't made their own form in their entire 30-year career.
Right.
Right. And so I think at that point, it's more incumbent upon the state association or the local associations that do have that broad base of experience that they need to make forms that make sense for consumers and make it easy on the consumer to understand what this is, as opposed to making a form that is for brokers by brokers written in lawyerly speak
Yeah.
to protect nothing but brokers. Because that
The
ain't gonna,
Consumer
that
Federation
dog
of
ain't gonna hunt.
America's, the
Yeah.
CFA's come out pretty aggressively on some, and they don't have their points aren't. They have some good points in their comments. Before we move forward, Keith, I know you want to. I just
Yeah,
want to get one last thing on the settlement question.
go ahead.
So if you join NAR before July, you can be included in the settlement. If you're not part of NAR in the settlement, just so that, and you can have, there's lots of people who are like, I want out of NAR and whatever, like they're essentially not part of the settlement. They could, in theory, become a new class of potential defendants, or like, what does that mean? I'm trying to help break that down from an easy, a broker's choosing, do I become or do I not? Like, what's the...
Right. So the simple answer is you were not covered by the language of the release. Right. But again, NAR in their skill and drafting of this, right? Just like the 2 billion brokers that are outside the thing, right? Are there some mediation opportunities? I'd have to look at that deeper to see if that would include a non-realtor versus just someone who hits the money mark. I haven't explored the agreement at that layer of depth.
To be clear, because I don't think we covered that, if you're above the 2 billion, for the small percentage of you listening that are, another option is if you don't pay the 25 basis points, is NAR will help you mediate some other concession.
Actually, it's really more the plaintiff. What NAR did, which I think again was an excellent job by NAR and their attorneys, they included in the agreement that the plaintiffs will go to a mediation session.
Got it. Okay, great.
And so you can avail yourself as one of these people that are outside the scope of this agreement, thanks to NAR's work on this, to a very quick mediation. It's going to happen like, within a few months. So you can get yourself in front of a mediator, talk to the plaintiffs directly, cut your own deal that makes sense based on what kind of volume and what you're doing, right? So even though NAR couldn't get this group covered under the terms of this agreement, they definitely provided a really nice, tight, quality mechanism to get this issue over with for you.
All right. Go ahead.
Your opinion would be, and because you've been doing this a long time, you've been a lawyer for a long time, is this it's smart for everybody just to join the settlement and get this behind them? Is that your overall opinion thus far on what you've read? Or, I know I'm putting you on the spot here.
I'm a mediator at heart. It's what I like to do. So I think resolving things is always the preferred method. Litigation sucks. It's brutal. Almost nobody wins.
Except lawyers.
Well, that's nobody, right? And so Yeah, I think this is definitely the path forward, especially for the industry where we are. Let's get back to selling real estate.
Yeah.
Yeah.
I would love to
Amen.
be at these conferences where we get the last 15 minutes and half the audience is in a lobby bar, right?
Mm.
Instead of us lawyers being the first ones after the keynote speaker, right? Let's get the
Yeah.
lawyers off the stage
Yeah.
and get back to, how to be great realtors, how to be great representatives of buyers and sellers. I think overall this is a really good positive direction to go, and MLSs will still be strong, right? Buyer representation will still be strong even with these rule changes in place.
All right, last one, and I think we'll all do this quickly. We got a few minutes left. We'll go Ed and then James, and then I'll go last. Ed, what should everyone that's listening, if you're an agent or a broker, what should everyone do now? Like, what should they do today, in your opinion?
You really better understand buyer representation agreements and work on that. Understand where that plays both in the importance of an agreement to you and protecting your interest and your rights, but also the fact that look at the world we're going to go into. Every single buyer is going to be presented with an agreement before they ever walk into a house. What does that mean with what that agreement looks like from your marketing and how that fits into your processes? And also, I need to talk to the listing agents and listing brokers. You are going to have conversations with your sellers. You are going to have to, when you do a CMA, you're going to need to back out in the current system we have today, where we do have comp in. As we transition to this new world, you're going to need to back out. What does that comp? Because you're going to get the seller going, cool, I'm not going to pay anything. All right, fantastic. Then see these 7 comps I gave you? All of them had the seller paying something to the buyer's agent. So let's go ahead and back all those numbers out. Since you don't want to do that, that better not be a part of your value either, right? And it's going to be incumbent upon you as listing agents to train your sellers and let them understand that relationship that exists currently on comps between the amount going to buyer agents and not into the seller's pocket, and that infects things. And that may help you when you get an offer that asks for some kind of help or compensation. So, get out there, get your training, get trained up on how to work with both buyers and sellers with a couple of these new wrinkles. And that's all they are. They're a couple of new wrinkles, right? You guys can get through this.
James, what would you advise an agent or a broker owner go do right now?
Yeah, so to me, it's treat your buyer the same way you treat your seller. Sit them down for a consult, get really good at a buyer presentation, get really good at articulating your value. NAR did a really great piece called 105 Things That the Average Agent Does with a Buyer. You can look it up. It's a great piece to include in your presentation. There's a lot of great buyer presentation software out there. And then also there's an amazing product coming to market that a lot of the industry has been involved in called Raise. I would highly suggest you will go check it out, RAYSE.com. That's going to be something that is going to help you articulate value in ways you've never seen before. I firmly believe that this is, as Ed put, is a wrinkle. I'm being aggressive here. We're not going to let the lawyers win on this. And there needs to be buyer representation. This is an infrequent transaction that people do a few times in their life that people don't understand. Is part of the reason why compensation is offered to the buyer's agent, is so that you do not have an unrepresented buyer in a very difficult transaction. There's lots of other reasons, but I firmly believe this is a time for our industry to step up. We need to get better. We need to train better. We need to articulate our value better. And every study that I've read, every single study that I've read shows that buyers want representation. This is not Australia. I don't care what examples people were using in the trial. It's not the same business, not the same concept, not the same country. And we're gonna come out the other side. And this industry is, I think, going to be different, but we're going to still be at the center of the real estate transaction. It's up to us to make that happen. So,
yep, I agree with what you both said. The only piece that I would add, I think, is a mindset component. There's going to be a lot of fear that's going to get communicated. I've already seen it. We've all seen it on social media. There's going to be a tremendous amount of fear primarily from a lack of understanding, from confusion. The three of us have spent hours poring over this document, and we still haven't fully internalized it. Be afraid. I'll give you 24 hours to be afraid. Okay, I'll let you have a day. but by 2:25 Pacific tomorrow, stop being afraid and start being curious. Be curious about how you're going to change your business, how you're going to modify your approach to what could most likely be, again, proposed settlement, but what could very much most likely be our new normal. You can either look at this as a calamity or an opportunity. And I give you 24 hours to be afraid. And then it's time to get very, very curious.
Every time you're afraid, pick up the phone. Keith always says this, pick up the phone and call a past client. Use that as your mechanism to do it.
Let the fear trigger the action that will actually help you and your family and won't cancel Christmas and all those good things. We'll have more on this on our podcast, which is Real Estate Insiders Unfiltered. And special thanks to Inman, of course, for hosting this. Hopefully they will have us back. We can continue to do updates as more information comes out. James, Ed, everyone at Inman, thank you so much. All of you listening, we hope you got value from this. I'm sure you have a lot of questions. I promise over time, those questions will get answered. Just stay curious, stay motivated, look at this as an opportunity. Thanks so much, everybody. Have a wonderful rest of your Friday.